My Lords, this is obviously a bill with good aims to reduce the prison population and put more resources into probation and rehabilitation. However, the problem is that the prison population is going up in the long term because governments keep coming up with new reasons to lock people up. We've had a lot of briefings on this particular bill, and a recurring theme across them is the issue of resourcing and capacity within the probation and rehabilitation system. Several organisations, notably Justice, stress that without significant investment in probation services and community-based interventions, the proposed reforms risk placing unrealistic demands on an already overstretched system. The Howard League for Penal Reform and the Prison Reform Trust cautions that while the bill may provide short-term relief to the prison estate, it will not be sufficient to address the long-term growth in the prison population, which is driven by sentence inflation and systemic pressures. For example, the government estimates that the sentencing bill will reduce demand for prison places by 7,500 places by 2028. This reduction is achieved through a combination of reforms, including changes to sentencing, release points, recall processes, and remand measures. Despite this, the prison population is still projected to increase by 2,000 people by 2029. Concerns that the proposed earned progression model risks becoming a mechanism that punishes poor behaviour is certainly valid, rather than genuinely rewarding good conduct. And there's the danger that adding additional days through prison adjudication system would result in a prisoner reaching the end of their sentence without the licence period. In addition, increasing the use of fixed-term recalls to prison isn't going to improve the situation for victims or the offenders. I've heard from those working with victims of domestic abuse about their fears for offenders being re-released without any assessment at all to the risk they pose to the people that they have offended against. And, of course, they're being put back on the streets and could commit crimes against other people. It certainly doesn't improve the lives of those being recalled. Sending somebody back to prison for 56 days doesn't allow them access to any offending behaviour work or reduce risks, but simply holds them in an overcrowded prison before they come back out, often having lost their accommodation and any progress they made before the recall. On the probation resources, there is a broad support across organisations for the presumption against short custodial sentences of 12 months or less, and for extending the court's powers to suspend custodial sentences of up to 3 years. The Justice briefing underlines the need for adequate resourcing of various services alongside guidance and training for practitioners. The Howard League, Justice and the Prison Reform Trust stress that the implementation of these provisions must ensure a genuine reduction in the use of custody rather than the reconfiguration of existing penalties. And Refuge urges government to ensure that domestic abuse offenders are exempted from the presumption against short custodial sentences and that appropriate monitoring arrangements are established. Now, while I welcome using rehabilitation measures in the community as opposed to in prisons, a clear theme runs through many of the briefings we've received, that without the serious investment, the proposed reforms risk collapsing under their own weight. And I would be very interested to hear the Noble Lord the Minister actually reassure us on that, because we could spend endless amounts of money, but if it's not spent in the right way, then it's a terrible waste. There are many issues that I wish I could pick up. The Howard League supports amendments to the Bail Act of 1976 designed to reduce unnecessary remand, particularly for pregnant women, primary caregivers and the victims of domestic abuse. Justice further advocates for the removal of the court's powers to remand individuals for their own protection, including children remanded on welfare grounds. Now, not included in the bill, for example, the Law Society highlights the opportunity for the government to revisit the re-sentencing of individuals serving indeterminate sentences for public protection, as previously recommended by the Justice Committee in 2022. As the Noble Lord the Minister knows well, IPP prisoners have been languishing in prison for petty crimes. IPP releases, in August, there were 172 freed for the first time, while it will take an estimated decade to free 2,544 prisoners still trapped in their sentences. I would like a commitment from the government about, if the government is keen on bringing down the number of prisoners, then please don't release men charged with domestic abuse and stalking who are repeatedly harassing women. And here are 3 things that the government could do instead. Abolish the draconian anti-protest laws that result in 5-year prison sentences for hanging a banner over a bridge. Reverse the prescription of Palestine Action, which has led to hundreds of arrests for sitting down peacefully and holding up signs. And personally, I want the Home Office focused on keeping violent prisoners in prison and letting peaceful protesters out on the streets trying to make the world a better place.